This is breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
That's so funny. You just scroll through and you got pictures of something you can eat.
That is like a goddess, okay?
That's what you say.
Yeah, of course.
He's not embarrassed. He's
Oh,
That's so funny.
Assistant Sheriff Wall. And then two assistant sheriffs to the other two. So there's three assistant sheriffs. You know how familiar you have to be with their structures. Yeah, right. Above that, captain, deputy chief. There's 6 or 7 of those. Yeah. They know that we're virtually, and I know we're still around them too. It's very higher up. That would raise over to the civilians. Oh, yeah. Is that right? Yeah, yeah. But I hear they're making some.
What's your position on us? Okay.
I was thinking that we have to.
Except we kind of been told by the court we were invited, that we wouldn't be here with him if we were part of that.
Why is there so difference?
Why is there so difference? They're separate issues. Okay, well, I just,
Yes.
okay, would you guys do that?
I'll check it.
Okay.
Police Department. I believe my co-counsel, Jacqueline Nichols from Marquis Arbach, might be on Blue Jeans. If she is, the clearance for her.
I don't see her name.
Okay, we can proceed.
Okay, but if she signs in. Hi, good afternoon.
Good afternoon, Your Honor. Ashley Kissinger on behalf of the Las Vegas Review Journal, Inc., Keith Moyer, Glenn Cook, Anastasia Hendricks, Brianna Erickson, and Arthur King.
Joel Taskett, Your Honor, for those sleepwalkers.
Good afternoon, Your Honor. David Chesnut and Rich Schoenfeld, on behalf of the Review Journal. And Your Honor, are we here on the criminal case or the civil case or both?
Probably both.
Okay.
Probably both, because I have issues that will probably affect both of them.
Okay, so our position, we made a request that we be able to formally be considered interveners in the criminal case as well.
I mean, that's one of the issues that
Okay.
I think we need to consider today, because I know there was actually a motion
Okay.
filed yesterday to that effect. Okay, and one of the reasons I'm not sure how we're supposed to get things to you now, Mr. Tellis, because Mr. Faulkner has indicated to us that he no longer represents you.
Right, well, frankly, I had a meeting with my investigator at 2 o'clock today.
Oh, it's a new one?
Right,
Okay,
so
perfect.
he's gonna be lined up to be my, my service person. So
Okay.
he'll be listed, his email is listed for e-service for me.
All right, because Mr. Faulkner gave Pam an email address and told it, I mean, we didn't get that person's name or anything, but he said,
He wouldn't have known who my new investigator is, so I'm not sure where he got
okay,
that from.
so then you want us to just ignore that?
I would, and again, I'll make sure that, I file a notice with the correct email address.
Okay, I mean, because you don't have email access, right?
No, I do.
So it would go to your investigator?
Correct.
Okay, because since he wouldn't accept anything, I just didn't know what to do other than bring you over here today.
And frankly, I don't know what this motion's about, I haven't read anything, so I'm not
You've been
there.
given a copy of the proposed order, correct?
Just now, yes, and I certainly got my objections to it, but that's all I've gotten. I haven't gotten this motion if it's supposed to be heard today.
Well, we're probably gonna discuss it, but I mean, if the parties want further time, I'm not even sure we need to do that, but, I just wanna make sure you got a copy and you can, if you wanna, state your objections now, you may, or if you wanna,
Well, I'll certainly wait till, other folks have stepped in.
okay, perfect. And I did hear from the state, so I wanted to give you an opportunity to,
Good afternoon, Your Honor. Tom Martin on behalf of the state. Our feelings about the proposed order,
right,
we have no objection to it.
okay, so I didn't receive anything, so I just wanted to make sure.
Sorry.
And, I did receive written pleadings from Metro. Did you wanna add anything?
I was looking at the proposed protocol again this morning, and I know we didn't object. The only thing I would say is that the part where the review journal receives all of the relevant material is not exactly how we had proposed it. We had proposed that they would receive only journalistic materials. So, I mean, I'm not going to make too big of a deal about it, but I think, I would object to that part, because what we know now is that when they receive relevant materials, in this case, they can publish a story if they'd like to. So the way I had it working was that they would receive only journalistic materials and not just everything that's relevant. But other than that, no, there's no objection.
Okay. Does the RJ want to be heard further?
Your Honor, no, I just, for the record, I wanted to make sure that you saw that we filed a brief today that just.
Oh, another one today?
Yes, Your Honor, I'm sorry.
Okay.
We, in response to Metro's brief called the non-objection to your draft order, it gets complicated, we filed actually a motion to leave to file a response to that, simply because in that brief, they raised a legal issue that has never been raised in this case before.
Waiver?
The waiver and judicial estoppel argument. So we simply filed a motion for leave and attached to it as an exhibit what we propose to have filed in the record so that our response to that argument is in the record. So we filed that today.
Okay. I didn't see that, but I can review it. I mean, I haven't reviewed it, prior to this hearing,
That's fine.
because I didn't realize.
Well, could I briefly speak to the waiver?
Absolutely.
Okay, so in brief, what it says is that it's very clear under Nevada law, both under the statute, well, actually, under Nevada Supreme Court law.
Now, didn't the Diaz
Diaz.
say we don't
That's right.
have waiver in Nevada?
Diaz says there's no waiver of this particular privilege in Nevada, the reporter's privilege cannot be waived. And the reason why it cannot be waived, even though other kinds of privileges that arise from confidential relationships, like the attorney-client privilege, can be waived, is that, again, this particular privilege arises from a different public policy reason. It's there to protect freedom of the press, to encourage people to come forward so that, you know, the press can write about the matters of public concern that it writes about. And so the Diaz court said, for that reason, this particular privilege can never be waived. It also flows from the fact that the statutory absolute privilege under the Mitch-Shields statute applies not just to unpublished information and confidential sources, it applies to even non-confidential sources and information that has already been published. So it would be sort of counterintuitive to, you know, say that, oh, you can waive this privilege by disclosure, even though the statute itself says, oh, you have a privilege in stuff that has already been disclosed, if that makes sense. So the waiver argument that they have raised is it's not accurate as a matter of clear Nevada law, and neither is the judicial estoppel argument, because the purported waiver by the Review Journal was not done in a judicial proceeding. It was simply done to try to help Metro find Mr. Bierman's murderer. So that's the argument on those two legal issues. And then if I may, Your Honor, I just wanted to make sure I conveyed kind of the two biggest concerns that we have going into this final stage of you entering your search protocol order. And there are really two big concerns. One is, you know, given the issues at stake, we urge you to incorporate into the actual order that you enter a stay of the order immediately upon its entry. Because we already have all these issues up before the Nevada Supreme Court in civil case, in the consolidated appeals, and they have already created an easy pathway to get your order back up to them, knowing that, you know, one or the other parties is going to be appealing it.
I mean, I know that you indicated you thought you needed to intervene, but that order, I mean, the order that I issue in this case, it has to be certified and filed with the Nevada Supreme Court, and the order indicates that if either party wants to amend your notice of appeal, then you will be permitted to.
That's right.
There's clearly a way to get there. You don't have to file a writ. I don't even think you have to intervene in the criminal case.
Okay, Your Honor, the reason why we were concerned is that when you circulated your draft order on Friday, it had both case numbers. It had the civil case number as well as the criminal case number. The appeals and the limited remand that contains that language with the pathway, that's only over there in the civil action. So the order that you enter, in order to have a clear right of immediate direct appeal under Nevada Rule of Appellate Procedure 3A in the civil rules, is over there in the civil case. If you were to enter the order also in the criminal case, the law is not clear that we would have a pathway. I mean, I think that that's what the Supreme Court intends, but they don't know that you're planning to order it in the criminal case. And when you look at the rules, Nevada
It's
rule,
only relevant to the criminal case. So, I mean, that to me is
Well,
logical,
no, it's
that
not,
it would be
Your Honor.
issued in the criminal case,
No, Your
because
Honor.
it's,
Just a second. Your Honor, the whole thing that got all of these proceedings started happened before there even was a criminal case. We needed to assert our rights over these materials because Metro was advising they were on the brink of searching them, and they felt they had the right to search them. So we had to rush into court before there was even a criminal proceeding. It was still in justice court. And so when you do that, under the motion for return of property statute, you file it as a civil case, which is what we had to do and what we did do. Therefore, all those issues rose up to the Nevada Supreme Court in the context of the civil case. So it's relevant. I understand what you mean by, of course it bears on these proceedings, but the relief that we are seeking, we seek over there in the civil action, and we've always thought it over there, and the Nevada Supreme Court has said this is the appropriate place for it to be, and this is the appropriate place for
So they
you
have the
to
civil
enter
case
that.
number, and I issued in the civil case
Yes.
and the criminal case, everything is fine, correct?
No, Your Honor, for two reasons. Number one, I don't even think you have jurisdiction to enter it in the civil case, the criminal case, given the Nevada Supreme Court's, I'm not sure, but
Okay.
there may be a jurisdictional issue, given what the Nevada Supreme Court wrote in its limited remand order in the civil case. That's number one. Number two, what I'm trying to explain, and maybe I'm not doing it artfully, the Nevada Rules of Appellate Procedure, there's one set, right? There's not a civil set and criminal set, there's one set. And 3B says, these rules govern in criminal proceedings. So then you go back to 3A, which gives the right of a direct appeal from an order dissolving an injunction. But the title of 3A says civil proceedings. So it's not clear to us that we have a right of direct appeal over there in the civil criminal case, which means that if you enter it in the criminal case, to preserve our rights, we're gonna have to file a writ petition, which is not something I think the Supreme Court would want or is anticipating. And I don't think you even need to enter it in this case, because it's going to be appealed, right? So there's nothing going to happen over here in the criminal case that requires you to enter it here. I mean, ultimately, whatever order the Nevada Supreme Court issues that says, here's what gets to be released to the parties in the criminal case, that, at that time, an order should be entered in this case, making that clear and allowing that process to occur. But if you do it before that, you're going to create incredible procedural complexity at the Nevada Supreme Court level, and we're gonna have to incur, great expense, because a writ petition, you basically have to file your opening brief. It's long, right away out of the box. So I don't think you need to, I don't think you can, and I think that you should, just for all kinds of prudential reasons, enter your order only over in the civil action. Did I miss anything?
And if you, for some reason, do not do that, Your Honor, by staying the criminal order while we do what the Supreme Court said, to fast track it back up, we will get a ruling on the whole issue, which will then give guidance to the court moving forward on the propriety of the order that you are about to enter, without causing a problem with having us going up on the civil side, but the criminal side basically trumping what the Supreme Court is letting us do if you just put it into action. So by staying it, all you're doing is protecting us, and it's actually why I asked if we were interveners, because if we're not in the criminal case, we're just in the civil case, and in order for this very important constitutional question to be addressed by the Supreme Court, it would be, in essence, if they agreed with us, but you entered your order and didn't stay it, the damage would be done.
That's right. So that could be a way to account for the whole issue.
Yep.
Thank you.
Anything
Can I
else?
react on that?
Yeah, of course.
So, I mean, a couple of quick points. So, I don't follow the logic of a protocol being entered in a civil case when the protocol is governing the evidence in the criminal case. So, this brings us back to what I've been arguing since last October, which is that this return of property motion never should have been its own civil action in the first place. It always should have been included as part of the criminal case.
But what were they supposed to do if there wasn't a criminal case yet?
Well, there was
I mean,
in justice court, Your Honor, and it simply would have moved right up to you with the criminal matters that had been done that way. So I've been arguing that the whole time, and it's important because this is the same evidence that we're talking about, and only one judge should be considering what to do with it at a time, which is why I had asked the chief judge to move the civil matter at least to Your Honor, because I think that helps a lot. But the record needs to be made in the criminal case as to what's happening with this evidence. But to be really clear, when I asked the court to consider entering an order or indicating what order it would enter, this was back in January, Your Honor, I attached the proposed protective order, and this was in the civil case, right? I attached a proposed protective order that I was asking Your Honor to indicate that it would grant. That protective order was, I had the caption as the criminal case. So when we asked the Supreme Court to remand the matter in order for you to be allowed to enter a protocol, we also attached that same proposed protocol, and it had the caption of the criminal case. So I think the Supreme Court knows that the injunction is in the civil case, but the protocol is in the criminal case. So, I mean, if I had if it was a perfect world for me, there would be a separate order that dissolves the injunction, and there would be a different order that would govern the protocol. And then they're right, this all has to do with the standard of review on appeal, whether it's a writ or whether it's a direct appeal. I mean, they're going to be able to directly appeal from the dissolution of the preliminary injunction.
Well,
So,
I have to file the order.
right,
And it has to be transmitted to the court, so clearly they contemplate that they're going to review the order.
right.
And what they're trying to avoid is having to do that and then having to file a written criminal case.
Well, I feel like the proper procedure for them would be to have to file a written criminal case. But apparently they are not going to want to do that. So if they choose to do that, I think that's at their own risk. The order being entered in both cases, to me, it protects them. Because I've been arguing since the beginning that there is no jurisdiction whatsoever in the civil case. If they're only proceeding in the civil case, it could be that the Supreme Court agrees that there was never jurisdiction in the civil case. Now, poof, there's nothing left for them. So it makes much more sense to me that it would be, the protocol is entered in the criminal case.
Do you have an objection to the stay?
Yes.
Immediate stay?
Yes.
Go ahead.
Well, Your Honor, once he's done speaking, if I may, for a few minutes.
Yeah, of course. Would
Sir?
you-
Sure.
Counsel, you may
Of course.
proceed.
Well, I'm sorry.
No, you may proceed.
Okay. In terms of the waiver, and I think Ms. Buckley wants to be heard on this as well. There's a couple of critical points, and this goes back to what we were just talking about. Are we talking about a stay in the civil case or a stay in the criminal case? There's no stays
Wouldn't it
available.
make any sense unless it stayed in both? Because if you don't state in the criminal case, then the order is effective. You can go act on the order, right?
Well, yes, but the ability to obtain a stay in the criminal case is much more limited. There's the rules of appellate procedures that they're citing. That's Rule 8C is for civil cases. The rule for criminal cases ties it directly to Chapter 177, and it's very limited. There's only certain judgments and orders in criminal matters that can be stayed all. So, but if I may, there's that main issue. But again, I acknowledge they have a civil case pending. It hasn't been dismissed, even though I think it should be. It hasn't been dismissed, and it's clear that they can directly appeal from the dissolution of the preliminary injunction. So, in terms of the stay factors there, yes, I don't think they've met the stay factors, and we can go through them. I haven't had an opportunity to file anything. Are they likely to succeed on the merits? No. I mean, there's so many jurisdictional hurdles to overcome. I'm not gonna go through them all again today, but we've talked about tangible versus intangible. We've talked about, right?
Yeah, but have you read that unpublished decision that they, I mean, obviously you're familiar with that case.
Yeah.
Did you see how they just glossed right over that? And they say our statute is similar to the federal statute, therefore it applies. They don't even discuss the differences between our statute and the federal statute.
Well, that could be, but, I mean, it's an unpublished decision of the Court of Appeals. And, that issue, I don't think it was even, that wasn't even presented to them. That must be dicta. That wasn't the issue in the
Well,
case.
clearly it's dicta,
Yeah.
but, you
that
know, I
wasn't-
was looking to see how are they gonna handle that issue. And
Well-
I felt like it was just glossed over.
Well, beyond that, Ron, we could, I know you don't wanna be bored with me talking about their standing, that the reporter's privilege is personal, that we didn't take anything from the RJ, that a return of property action doesn't include the remedy of a preliminary injunction. We have all of those very fundamental issues that are really big hurdles for them to overcome in order to be successful on an appeal. But putting that all aside, let's say the Supreme Court agrees that they have some kind of standing. Are they gonna be successful on appeal when we're talking about this court's discretion in terms of how to handle the protocol that needs to be entered in a criminal case? We all know that courts have significant discretion when it comes to discovery matters. The standard on review is going to be against them, no matter if you entered their order or my order. The standard of review is going to be against us, whoever the opponent is, because you have a lot of discretion in this regard. And let's remember, it's not like you're not granting any relief whatsoever to them. They've had some success through this litigation. Otherwise, we would have just already done the search. There's protections built in for them. There's a protective order that would be in place. There's only 4 individuals who have access, and those individuals are going to be under the threat of contempt if they breach the protective order. So is the Supreme Court really going to undo your protocol? If they do have standing, my position is no. The likelihood of success is low. Are they irreparably harmed? No. Again, we didn't take anything from them. The harm that they're talking about, that they're so focused on, is very speculative harm to other people. These confidential sources that we're going to out when we go through the materials. Very, very speculative, especially when there's a protective order in place. If they don't have standing, or if their standing is very attenuated, how are they irreparably or seriously harmed? Economic harm is not irreparable harm. There's case law on that proposition. There needs to be something beyond mere economic damage, which is part of what they're talking about in the brief. So, are they irreparably harmed? I don't think so.
They can't undo it.
Well, the object of the appeal might be one of the 4 factors that favors them somewhat. But again, are they getting exactly what they want? If that's the object of the appeal, them getting exactly 100% everything they want, then yes, the object of the appeal will be defeated. But are they getting some protection? Yes. So it depends on how you define the object of the appeal. And in terms of the irreparable harm to the state, I think Ms. Eckerly can speak more to that, but clearly the expeditious continuation of this criminal matter is irreparable harm. I mean, if a stay is entered, obviously it's going to disrupt the proceedings in the criminal case. The only chance that this criminal case has in proceeding...
Well, even if I denied a stay, the Supreme Court could grant one.
Well, but I was going to say, Your Honors, I'm sure that most courts would be inclined to grant some kind of stay, but it would usually be for some short period of time so they can ask the Supreme Court, let them decide. But I don't think the factors are met, and I don't think it should be what they're asking for from Your Honor, which is a stay all the way through the end of the appellate proceedings. It should be a temporary stay in order for them to go try to get one from the Supreme Court, which will oppose.
Madam Attorney?
I had points on the waiver issue, but maybe we should wait on that.
Before you hear from Mr. Tellis, Your Honor, this argument that I've been telling you this from the beginning means nothing because judges have already ruled on this. They've granted injunctions. The Supreme Court, if they had not felt that this was an issue of importance, would not have remanded to you for your thoughts on how it should be handled, and then giving us a pathway for the court to reconsider either us or them, what you decided to do. We've spent months trying to get a fair answer to this. The Supreme Court has told us that they want to hear from us again when you make your decision. Not to stay it in both cases would completely eliminate the possibility, if in fact the Supreme Court agrees with us, that the damage would be done. I know we were being told, and this is said with the most respect, Your Honor, I know you believe that a protective order will serve the purpose, but the fact is, it's blindness to reality not to know that the police are sources to journalists, unnamed sources all the time. That's what we're trying to protect against. The argument that somehow these police that you're designating are different than the rest of them when they leak stuff is not really.
Okay, but you're asking me to basically agree that people don't follow court orders.
Yeah.
So if people don't follow court orders, it doesn't matter who I appoint.
I understand, but Your Honor, in this kind.
Right?
Yeah, but Your Honor, in this case. the
Because I
whole-
live in a world where people comply
And
with
Your
court
Honor,
Okay,
orders.
but in this case, Your Honor, ostensibly, they say they are trying to protect Mr. Tellis's rights. Mr. Tellis has agreed with our protocol. So if they're really interested in protecting Mr. Tellis's rights, they would allow you to have placed before, in the order, a protocol that he agrees as the defendant protects him, and the one that we believe as the First Amendment advocates protects Las Vegas, Nevada, and everybody. One moment, Your Honor. And, right, Mr. Schoenfeld and Ms. Kissinger make a very good point. It's not so much that they're gonna disobey you. They are people whose protections the statute speaks directly to as not supposed to be looking at the journalist's work, per se. So it's not necessarily saying they're gonna violate. The minute they look, they're violating. Not your order, but the law. That's the problem. There's a conflict between your good intentions and what the law actually says, and it's for the Supreme Court to tell us whether or not we're right. And that's the process. And it would be a complete waste of all of this time, including the Supreme Court time. This is a matter of real judicial economy for them to hear this in a pure
No
way.
question they're gonna hear it.
I understand, but we want them to hear it without the damage having been done.
I understand.
Your Honor, so I think first of all, the folks that, and to be frank, you mentioned the fact that the folks that you know, that are subject to this order, the police and the prosecutors, that they will follow your order, they're gonna behave. The two Metro officers are the ones that violated my constitutional rights. The two prosecutors are the ones who are currently violating my constitutional rights. So if they're willing to violate the Constitution, I don't know how much they're gonna care about Your Honor's order, to be frank. And, whether, can you prove that they did? Can we, show that there's, that they didn't slip these sources to somebody else? That they didn't act in bad faith? So I absolutely disagree with having these four individuals who, again, two have absolutely violated my constitutional rights. They put me here wrongfully. And two who are trying to prosecute me while withholding evidence that I'm entitled to constitutionally. They should not be the same people who get to look at this other evidence and say whether or not I should be allowed to have it. It's just egregious. And then, of course, there's a simple concern with procedure. The motions that have been filed as far as I know, and again, unfortunately I don't have the ROAs in front of me, but as far as I know, everything's been filed in the civil case. So an order, very simply, I think should be filed in the civil case. And if we want judicial recognition of the order that was filed in the civil case, in the criminal case, do that. But the order is responsive to action in the civil case, and that is where it should go. It is a bad faith move for Metro to say, oh, well, we want to go ahead and have you enter in the criminal case too, because we want to make sure they have to run to the Supreme Court. In the meantime, we're going to rush to look at the devices. That's essentially what they're saying. It's a bad faith move, Your Honor. And I know I'm speaking colloquially, but it's very frustrating to hear that they are trying to game the system, that they're trying to say, oh, Judge, we're the superior authority in all of the land, in all of Clark County. What we say goes. And since, we're telling you that you should enter this order in the criminal case and let the RJ, let the defendant suffer, we don't care. It's just wrong. Procedurally wrong, it's immoral, it's wrong on all counts, Your Honor. Thank you.
Okay. I don't know, I believe that.
So-
I'm sorry, Ms. Wexler.
No, that's okay, I can be brief. Obviously, the state of Nevada is opposed to any stay. I guess you could do a limited stay so they could seek relief, like in that form, but we have a trial date approaching. We have a defendant who has procedural due process rights. We have a party outside of the criminal case asking for something to be delayed, his trial, where he's sitting in custody pending appeal. And so I'm concerned about any delay for an appeal to run its course from a stay from the trial court. So, I'm trying to prep for trial. There's relevant evidence in these devices. He's entitled certainly to anything exculpatory from them, and I know the court's aware of all this. So for those reasons, the state has concerns about the stay that's being requested by the RJ.
Okay.
Thank you. First of all, I wanted to make sure you were also aware that we have submitted to the Chamber's inbox our actual stay motion that we're filing here in your court, because it was on order short lead time, so we had to do it that way rather than file it in the record. So I wanted to make sure you were aware that that's already in front of you. That stay motion makes clear that it's a Nevada Supreme Court case that expressly says that delay of a criminal case is not prejudice, is not harm that counsels in favor of not granting the stay. So the argument they're making is just wrong as a matter of Nevada Supreme Court law. Sounds like both Metro and the state are consenting to at least a limited stay.
That's what it sounded like to me.
However, it sounds like they are suggesting that we should have to seek that stay relief from the Nevada Supreme Court. Your Honor has equal power to enter that stay. And
Right, that's what I said earlier. Even if this court didn't grant a stay, you can always seek a stay from the Nevada Supreme Court.
That's true, Your Honor. However, they have been telling us since early October that they were ready to search the devices, and that the moment they can, under the law, search them, they're going to search them. So, the
Right, so a
time,
limited stay would protect you.
Right, so my suggestion in light of their agreement is that you stay
At a minimum.
at a minimum. We would ask for the full stay, but at a minimum, giving us time to request. Nothing can happen until we've asked the Supreme Court if they're going to continue to stay. Good with that?
yeah, I think
Anything else?
I do think that the argument against the appeal, saying that, for some reason that's going to delay trial, and that they're concerned about trial,
I think it
it's.
will, and I'm
Well,
concerned
and-
that I know you
and
really
Honor-
want to go forward
Well, here's the thing,
in
Your Honor.
November. Is that still the case?
Actually, Your Honor, I want the impeachment evidence that I'm constitutionally entitled to,
Absolutely.
that they claim that they cannot give me, because that would actually resolve this entire case. We wouldn't have to deal with the RJ's issue, because I could actually defeat their case using impeachment evidence, defeat the search warrant, but yet there's, for whatever reason, they are hiding this impeachment evidence from me. And U.S. v. Bagley, I'm going to give you the case citation for the record, Your Honor. 473 U.S. 667 at page 676. The prosecutor has a duty to provide impeachment evidence and also exculpatory evidence. And when the prosecutor fails to do that, they are blatantly violating the accused's constitutional rights. So to say that they've got a constitutional duty that they're fighting for against the RJ, but at the same time violating their constitutional duties to protect police misconduct?
So are you referring to your discovery motion?
Your Honor, absolutely. And the point is that this is bad faith. To say that they've got to fight tooth and nail for exculpatory evidence from Mr. Gurman's devices, but yet they're going to refrain illegally from giving me the information I need to defeat the case and really send us all home without even having to look at Mr. Gurman's devices. It's just incredible. Absolutely incredible.
Okay, so are there outstanding discovery issues from your motion that we need to resolve?
Yes, Your Honor.
Okay,
Yes, absolutely.
all right, so we will set that, because I think we're gonna have to be a little more specific.
Absolutely, Your Honor. Thank you.
Your Honor, I'm trying to fashion some language on the stay issue.
Well, I mean, you filed a motion, I'm gonna obviously
Yeah.
set it for hearing and allow you both, to be heard, and we can probably continue the discovery motion until that date too, and maybe you can supplement and specify, because I know there were lots of requests which have been met and which have not.
Mostly not, but yes, sir. Yes, ma'am. Excuse me.
Perfect, that's fine.
Yeah, Your Honor, there's so many moving parts.
I know.
You're very patient, and I appreciate it. My understanding is that the Nevada Supreme Court's order of limited remand requires you to enter your search protocol order by Friday.
Yeah, that's true.
And so, putting off the question of whether we get a stay or not is not possible. There's literally, we're out of time. And so that's why we are asking you to, in your search protocol order, which you're gonna be entering, put that stay right in there. I mean, that will solve a lot of problems. Again, it seems to us, there's no reasonable basis not to give us a stay. I can't imagine that the Supreme Court won't give us a stay under the circumstances of this case. And you have the power to do this, to enter the stay for the whole appellate proceeding. So we're asking you to just do that, rather than this temporary stay, so that we then go to the Supreme Court and stay until they decide, are the motions stay there? I mean, we can proceed that way.
What's the problem? You're 100% certain they're gonna give you a stay.
Well, I am, but, so if that's more comfortable, we're okay with that. I'm just saying, you don't actually have to do that, and you have the power to enter the whole thing.
Your Honor,
Yes, sir.
the language I would suggest, Your Honor, if you're not gonna give the full Monty, would be that we ask you for a stay of your order that remains in effect until the Supreme Court rules on a request for a stay. And that be made part of your protective order.
So would it be a time period? It would just be whenever, I mean, how long does it take them to take up a motion for stay?
The last time, we asked for emergency relief, they gave it to us in 2 business days, so they're quick.
Oh, okay.
They're quick.
May I approach, Your Honor?
Sure.
And then, Your Honor, I just wanna make sure I dot all the i's and cross all the t's here. I also wanna raise, and you'll see this in the district, in the motion to stay, it's in your inbox. The order of limited remand also addressed that second preliminary injunction request that we made that covered the cars and future acquired news gathering materials. That temporary injunction is set to also expire on Friday.
As to the car?
And as to all of the request, it's basically, yeah, there's gonna be no injunctive relief other than over the seized devices. Our position is that, and you'll see it in the motion,
But the car is gone. Please tell me, we resolved it.
we didn't, Your Honor,
Yeah,
here's why.
Mr. Chestnut told me it was sold.
No, Your Honor, Mr. Gehrman had a Bluetooth-enabled car. It was leased. We have learned that the car went back to the leasing company.
Okay.
We don't know whether the leasing company has erased the electronic data from the car, which I understand to be not a simple process. We also know that Metro is a sophisticated law enforcement agency, that might go try to track down that leased car's, new owner and look at the electronics in the car. We've asked them, will you make a representation that you're not gonna do that? We can't get one. Will you make a representation that you won't go look at other cars that you think Mr. Gearman may have driven?
Does he have any other cars?
I don't know, but I'm not in, the investigative team. So they won't even make a representation, just let me finish this out and then you guys can speak. We asked for this back when we were litigating that issue, and we couldn't get a representation, which is why we had to battle that thing all the way through the Supreme Court. Your Honor's order denying that second preliminary injunction did say, I'm denying this because the car's been returned, but I don't think that you considered all the things that I'm saying to you now. And I also,
That would be crazy to me, that they released the car after they had seized it, allowed it to be sold or given back to the company, and then you think they would go after it later? Yeah, that makes no sense to me.
I don't know that they ever seized Mr. Gearman's car. We know that there was fingerprinting dust on his car, so they did some kind of external search. Whether they thought to do an electronic search, I don't know that they did. I don't know that they didn't. We can't get them to make any representations about the car. Also, Your Honor, there's this whole other category. I mean, they're continuing, like in all law enforcement investigations, they're continuing their investigation while this criminal case is proceeding. I don't know what has come into their possession over these 8 months. I don't know what's gonna come into their possession from now until the end of this case. So there needs to be a catch-all provision that says all this privilege protection that we're fighting over, whatever relief we get from the Supreme Court, needs to apply to that stuff too. And so I'm asking, Your Honor, that when you enter your search protocol order, or you can do it in a separate order, that you reinstate injunctive relief over those two categories of materials we used very specific language in that second motion for preliminary injunction. Only by doing that are we making sure that we cover all of the review journal parties' privileged materials. So I wanted to make sure we had asked you for that relief. If you just give me 1 moment, please. I want to make sure that we resolve the intervention question. Either way, we've appeared in this proceeding, you've allowed us to appear, nobody's objected to our appearance. We asked for consent to that motion for an order confirming us as interveners. Never got a response, that was 2 days ago. I don't know what their position is on that, but I'd like to hear it on the record.
I don't think you have to intervene.
Your Honor, there's this, again, we're trying to make sure we're buttoned up procedurally and that we have the record buttoned up procedurally in both cases. And there's a Supreme Court case that suggests that if you don't get intervener status, then you may not be able to take an appeal. So that would be another procedural way that they could get us right over there in the criminal case. So we really do need an official order recognizing all the review journal parties as interveners. Your Honor, I just want to respond to a few specific things that Mr. Christian said. He said that there was a criminal proceeding going on at the time, so we could have filed our motion for return of property in the criminal case. That's wrong as a matter of statutory law in Nevada. I can't remember what brief it's in, but we cited in one of the many briefs in this case to a Nevada statutory provision that says a criminal proceeding, which is the exact phrase used in the motion for return of property statute, starts when there's an indictment. And we filed our motion for return of property before there was an indictment. So the laws are crystal clear.
An indictment or an information?
It might have said indictment or information, yes, Your Honor. In this particular case, I think they proceeded by indictment, So we did file it in the right place. The Supreme Court obviously thinks they have jurisdiction, otherwise, we wouldn't be going through all the process there, that we would have been kicked out of court by now. I think the same is true of the standing argument. Let me just see here. I agree with what Mr. Tellis said, that, to address Mr. Christian's concern about, well, how are we gonna know? What's the record gonna be over here in the criminal case? You can enter your search protocol order over in the civil case and then simply enter a minute order or some kind of order, just, you know, stating in this case what's going on in that other case and, you know, what will come forward. The order of limited remand that is why we're even here and why you're able to enter a sort of protocol order states nowhere in it. I mean, I have read that thing back and forth, and I see nothing in there that would suggest that it would be appropriate to enter it in the criminal case. You're clearly seeing it as being entered in the civil action. I don't know if you were talking about the Nevada Court of Appeals unpublished decision about what you were talking about, if that was addressed to the tangible, intangible distinction?
Yes.
Okay. The search warrant statute has a definition that for property that says it's gotta be tangible property. That's the general definition. When you get down into the statute, there are certain provisions that speak to privilege. Now, it's the attorney-client privilege, because that's usually the one you're talking about in criminal cases, as you know. In that section, it has its own definition of what property is. And guess what? It covers intangible property, the kind of property that we're talking about here, you know, in connection with this other privilege. So,
Well, clearly that's what they were talking about in this case.
intangible,
I mean,
yes.
it was intangible.
Right, and so they didn't, you're right, maybe they didn't address it expressly, but I wanted to make sure you knew that actually has a statutory basis for it as well as that decision. I can't remember exactly what Mr. Christian said that made me want to say this out loud, but I think it was on the merits, the discussion about how we're not likely to succeed on the merits. You know, part of what we're arguing here is very serious constitutional rights of the review journal parties, not just a state statute, even though that state statute is extraordinarily strong. It's one of the strongest in the nation, as I think I've said a few times. And we've also briefed recently, to your honor, the notion that when the press's First Amendment rights come up against Sixth Amendment rights in the criminal case, the presumption is that the First Amendment rights prevail. So the notion that we're unlikely to succeed on the merits, to me, is belied by, you know, a lot of bodies of constitutional law. I'm surprised to hear, I guess the last thing I'll say is, I'm surprised to hear that Metro and the state are taking the position that, you know, we may not be able to intervene in this case. We may have to file a writ petition over in this case. You know, they've been fighting for so long, making this argument that, oh, you guys are doing it all wrong, doing this over here, this civil case, which we are not. And then we get over here, and they want to preclude us from being able to assert our rights here. I mean, it's just, it's fundamentally unfair, and it would violate my client's due process rights. So I'm surprised that the argument's even being made. I think it's frivolous. And now I'd just like to see if any of my colleagues think I've missed anything. I'd like to ask Mr. Tellis on the record whether he consents to the review journal parties being recognized as interveners in the criminal case.
I would, Your Honor. I would consent.
Okay.
So just wanted to make sure we get that on the record. And so, you know, I guess I'd like just another opportunity at the very end, when you decide how you're going to deal with all of this stuff, to kind of like mentally go through a checklist to make sure that we've covered everything. Thank you.
Okay, because you said you don't want a hearing on the stay. I mean, I was gonna grant you a hearing on the stay and be able to read your briefs. I can do it tomorrow. If you wanna do it tomorrow, I can do it at the end of my criminal calendar.
Can I consult with my colleagues?
Sure. Or you can submit it on the pleadings.
is your Honor's current inclination? Are you inclined to go ahead and put that stay in the order?
I mean, at a minimum, the parties have agreed to a limited stay. So at a minimum, but I want an opportunity to read the pleadings that have been submitted.
Let me suggest this, Your Honor. Do you think it would work to enter a limited stay until Your Honor can read our stay motion and consider it at that time, without a hearing? I think I need to make sure my client's okay with that. But that's my idea.
Well, a limited stay would be sufficient if it indicates until you have an opportunity to be heard by the Nevada Supreme Court.
I think that would be
I'm
best.
sorry, I think
They've
Right.
already presented,
That would
they've
be
already
best,
presented language to you,
Yeah,
Your Honor,
just-
that I agree to.
Right, I think
maybe
that,
I've overlooked something.
yeah, if I enter the stay, which indicates it remains in effect until you have an opportunity to seek relief from the Nevada Supreme Court.
Then we don't need to have any more hearings on stays.
Right,
We don't-
it would,
Well,
it will be until the Supreme Court rules on whether we get a stay, it would be a stay.
Yes.
There you go.
Great.
So the
Yes,
next
Supreme
move
Court
that they
rules
can,
on a
the
request
next
for a
move they
stay.
make when it comes to stays will be in the Supreme Court. Until that time, there will be a stay in place.
Did you say, maybe, is that different? Is that
No,
typically
no,
different?
no, I
Okay.
just want to make sure that my agreement to Mr. Chesnoff's suggestion is on the record.
Your
And I
Honor,
think Ms. Buckley agrees as
You
well.
guys agreed on something.
Yes,
You
see?
should probably stop.
So I think the clarification is whether or not it's a stay through the appeal or a stay until.
No, it's a stay through the point that the Supreme Court decides whether to extend the stay,
Right, until the
Which
Supreme
is-
Court
which
decides
is
to
a very-
issue one at all.
which is a very common way of proceeding.
And that's the language that was presented.
Right, and perhaps the court will mark my scribblings as part of the record, so it's clear what we're agreeing on.
Okay?
Thank you, Mr. Chesnoff. Can I go through my bullet points? in
Is there
response?
more?
Just a
Okay.
little bit. I think I have to respond to a couple
Okay.
of the things that Ms. Kissinger said. Sixth Amendment versus First Amendment. The very case law that they're providing makes it very clear that the First Amendment yields to the Sixth Amendment. So we've already talked about that, and I think that's already well established. Tangible versus intangible in this unpublished order, Your Honor. Ms. Kissinger made the case for me. That case was about attorney-client privileged material, which of course is intangible. And like Ms. Kissinger points out, there's a whole different statute governing the attorney-client privilege and key teams that have to be set up in order to go through that. So that's attorney-client privilege. We're talking about a regular motion for return of property that's governed by 179.015's definition of property, which is only tangible property. So that's my point on that. In terms of motions for return of property being only heard in district court, I can't tell you how many times I've appeared in justice court opposing motions for return of property. If Ms. Kissinger is right, the next time I get a motion for return of property from someone who wants their money back, or their gun back, or their identification back, and the case is in justice court, I would be able to say to them, oh, sorry, you have to file a whole new lawsuit in district court in order to get your ID back. That's exactly 100% the opposite of what was intended when the legislature changed that statute. I've read the legislative history. The point of including subsection E, which is that you can have your property back if it's unreasonable under the circumstances for Metro to retain it. The whole reason they added that was to make it easier for people to get their property back. And making folks who are only in justice court go to district court does not make it easier. It makes it much harder. And the other point is that there can only be one court at a time hearing things. So if you've got a justice court case pending and the ID is evidence, and then we've got a district court case pending that is for return of property, it doesn't make any sense. It has to be in the same case. whether it's in justice court or in district court. I've appeared in both on motions for return of property. The Supreme Court has not decided whether there's jurisdiction in a separate civil lawsuit for a motion, on a motion for return of property when a criminal case is pending. We filed a motion in the Supreme Court to dismiss their appeal based on that theory. They opposed it by arguing that motions to dismiss in the Supreme Court are very rarely granted, and so the Supreme Court needs to hear full briefing on the jurisdictional issues. So they have never decided whether there's jurisdiction, and when we're on appeal, we're going to continue to argue that there's no such thing as a separate civil lawsuit for return of property when a criminal case is already pending. We're going to continue to argue that. In terms of intervening and not being able to agree with it right now, remember, this is a completely different position we've been taking since the beginning of this case. Been begging them, please, just let's litigate this in the criminal case. No, we
Well,
have.
that was kind of too late.
They've been insisting that a separate civil lawsuit exists.
Right, because now it's up on appeal.
Well, for all these reasons that we're talking about, that their standard review is easier, that they won't have a judge who presides over criminal matters and has to deal with Brady and Biglio issues all the time. They never wanted you to hear this case. They resisted it being transferred to Your Honor. They never, ever wanted this matter to be
No, I
heard.
think we need to go backwards.
Well, what I'm saying is
How
that
can they not tell you that we can intervene and then tell us we should do this?
they should have agreed a long time ago to have this matter heard in the criminal matter. They never wanted to. Now suddenly today, or yesterday, I'm being asked to let them intervene without being able to research it or anything. The ability to intervene as a third party in a criminal matter is limited. So I'm not prepared to agree with it. I'm sorry.
He's a third party himself, by the way.
Exactly.
That's a very hard third party.
You're right, that's a very good point. You're right, that's an extremely good point.
So,
You're right, let's go down
Your Honor, by the
the
way, just with the justice court thing, just really quickly, just get in there and get it back out. It was because of the objection by the DA that the RJ was not allowed to step into the criminal justice, or into the justice court matter. So it's disingenuous to say, first of all, in the justice court matter, you cannot be in this matter, you cannot seek relief here, go to civil court. And now they're saying, well, you should have stepped into justice court, not civil court. They're just flip-flopping.
No,
Again,
that's
bad
not-
faith. It's on the record.
That's not what happened. The Justice of the Peace decided it was a different motion. They never filed a motion for return of property in justice court. They never filed a motion for return of property in justice court.
Can you
But-
make representations about this car? I mean, because I really thought we
My-
had put the car to rest, that Mr. Gitterman's car had been returned to the lessor, and that you're not gonna try
Mr.
to...
Chesnoff figured that out.
Right.
But they never seized a car, that's my
Okay, but
understanding.
you don't intend, Metro doesn't intend to go seize it?
Not that I know, Your Honor, no.
See,
Not that I
this
know.
is what,
Then-
these
then
are the
how would
answers we
I
get.
know?
Your Honor, out of an abundance of caution, just do what Ms. Kissinger said.
See, that's why she's asking me to include,
The language they want included
The
is
car.
the vaguest, most ambiguous language that you can imagine. Any future seized material that a reasonable person may believe might contain journalistic materials, we're supposed to know exists and that we somehow protect it. I mean, we can go back to what Judge Johnson said. That's not specific enough for a Rule 65 preliminary injunction. It has to be very specific.
well, the car's pretty specific. Do
We
you
don't
intend
have, we don't have possession of a car.
Okay, but do you intend on seizing it in the future?
Not that I
I mean,
know
I
of.
think you'd have a big problem if you did. I mean, because you'd have a chain of custody issue.
I couldn't agree more, Your Honor. I mean, it's almost borders on paranoia. And it's not just the car, it's these other cars out there too. If you
I
read,
don't know what the other car
they use the word plural, the car and any other cars. What other cars? I don't know of any other cars. That's not specific enough to put Metro on notice of what it's enjoined from doing. That's not specific enough. If, and this gets back to Sandy, if we took something from them, they would know it, and they'd be able to come to you and say, Your Honor, I need an injunction because Metro seized our property, and we don't want them to search it. This is completely vague and ambiguous because they don't, nothing's been taken from them. We're talking about things that might be taken from other people, and they don't have any interest in that.
Well, the privilege, I mean, the Sun case says the privilege extends to the editor of the newspaper
Well, I mean,
in the footnote.
right.
I mean, they put it in the footnote and said, we're satisfied that the legislature intended to include them, even though the legislature didn't include them.
The point of that was that it was the editor the one that gathered the news material.
No. I mean, they said that the privilege extended to the editor.
Because
it's in the Las Vegas Sun.
Obviously, they're protecting the sources of the entire
It
organization.
was
It's not,
it was Mr. Greenspan that they
It's silly.
included.
Your Honor,
It
he
extended
wrote
to-
that. He wrote the editorial. He wrote the editorial. He was a party to the lawsuit as the editor. It doesn't intend that you have to be the one that gathered the news, that gathered the information. It's personal in nature. So again,
Right,
that's,
there's no question it belongs to the reporter.
yes. I mean, this again is an issue for the Supreme Court.
Right. I mean, and what happens to it when you have the reporter that passes away?
I mean, my final comment, Your Honor, is, you know, this was always a good faith dispute. It really shouldn't have turned into what it's turned into.
Well, that's what I think too.
We simply wanted to be able to search the devices ourselves. They simply wanted to have a special master. It should have been presented very quickly to the court with jurisdiction, and it should have been resolved, and it would be over by now. But we have the introduction of all these appellate issues, motions for sanctions, the introduction of new parties, the removal of certain parties, removing one of the plaintiffs without asking leave of court.
Well, I was gonna ask that too, because I'm being told that these other people need to be in the caption. Were they plaintiffs? Did someone move to amend?
No.
Okay, so they were plaintiffs and, okay, I just wanted to make sure.
Judge
That was
Johnson,
before it came
Judge
over here.
Judge Johnson called it playing fast and loose with the rules, I think is the quote from Judge Johnson. We were there one day, she issued verbally a preliminary injunction, we came back the next week. Suddenly there were more plaintiffs. There was an amended petition.
Had anyone answered yet? Were they allowed to amend without
No.
leave of
Their
court?
position is they don't have to have leave to amend. So Judge
Well,
Johnson's,
sometimes you don't need leave to amend.
Right.
If there's no answer, you don't.
Right,
need it.
that's why I asked, had anyone answered yet?
And it was,
but
yeah,
they,
if no one's answered, you can amend your complaint.
it was very fast.
right, if it's proper to have a civil lawsuit, and if it's proper to use all of the rules of civil procedure, right, I mean, Rule 81 says that all of the rules of civil procedure don't always apply to it. So this is not a regular civil lawsuit by any stretch of the imagination. There's no complaint, there's no
I
answer.
understand why they want those individual names
Okay,
in the
right.
caption.
But just one quick point. They added 6 individuals without moving to amend, okay, maybe they can do that. They've added 6 plaintiffs. Now, fast forward a couple months, there's only 5 now, Your Honor. In case you didn't know, there's only 5 now, because one of them doesn't work there anymore, and so now it only needs to have 5. Well, there's no motion to remove any plaintiff from the caption.
So
There's no
probably-
motion to
still 6
withdraw. Yes, there's still
How's
6.
that a harm at this point? I mean, we're talking over about something that's pointless.
Only the rules that they want to follow are being followed. The rest of the rules, they don't bother with. That's my point.
Your Honor,
Okay.
I'm not gonna go relitigate every substantive issue with you. But I do just wanna say, because you said, gee, why has this taken this long? It's such seemingly acrimonious litigation.
Well, yeah, because it doesn't seem like you all can agree on anything.
I got
I-
That's
I-
why
I-
today
I-
I was so
RJ.
happy.
I got the.
I've given Mr. Chesnoff extension.
Yeah,
Mr. Chesnoff can call me anytime.
Okay, so I'm sure that you have agreed on other things.
The point, Your Honor, is we were forced we have been forced at every turn in this case to file the crazy pleadings that we have had to file because of the position that Metro and the state are taking. They are taking, you know, what I would describe as procedural gamesmanship to try to do whatever they can to avoid us from getting the relief they want, and that's, they're entitled to make their legal arguments. But, you know, first of all, we couldn't assert it in the justice court. Didn't have jurisdiction. I asked him in the hallway, let me know, where do you think we should be asserting these rights? We don't know. Meanwhile, they know all about the return of property statute. So then we go file the return of
Yeah, he
property.
represents Metro.
Right.
He better know all that.
They told me they did not know, literally in the hallway. And
I think we told them that it wasn't our ethical obligation to tell them how to proceed.
no.
We have our own ethical obligations to
I
our
got
own
shrugs,
clients.
literal shrugs. So we filed it where we figured out, after much expense and trouble, over where the statutes indicated we should. And we've been litigating it over there, and then we get the response, no, you're doing it wrong, you gotta do it over here. So now we finally get it over here. Oh, no, you can't intervene. You know, it's just, it's maddening. So the notion that we are responsible for spinning this out, I needed to say for the record that it's just absolutely not the case. Okay.
I disagree.
And Your Honor, of course you do. That, I just wanted to make clear that Judge Johnson was only addressing the caption with regard to the other individuals. She never removed those parties as plaintiffs. Nobody ever asked her to. She never did. She was only speaking to the caption, and that's what she was referring to when she talked. She said, I'm a real stickler for the rules, even for captions, and you guys are playing fast and loose with the rules, and so she changed the DA's office to State of Nevada. I mean, we're talking about just procedural things that hadn't gotten quite like she wanted. So it wasn't some kind of substantive ruling by Judge Johnson that the individual parties should not be parties.
You amended the complaint appropriately
Yes.
before anybody answered.
Yes, Your Honor, we did. 3 days after, which is within the time period that the rule allows you to amend as of right. I think that's all I need to say at this point.
Okay, all right, so at this time, I think we can conclude. Thank you very much.
Thank you for your patience, Your Honor.
Your Honor, for our next hearing?
You're on for a status check.
I'm sorry, what? We're not talking about trial readiness, right?
Yeah, the trial readiness is on July 5th.
Well, I was hoping, and of course, the judge about that, I was hoping that we would hear my evidence issue sooner. Talk about the lane things.
All right, let's go.
You've been watching breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.